right, so let's talk about something that's, well, a pretty tough part of the business world. What happens when a limited liability partnership, an LLP, finds itself in deep financial trouble and just can't pay its bills? It's not as simple as just shutting the doors. There's actually a very specific, very structured legal process that kicks in to make sure everything ends in an orderly way.
So, yeah, what does happen when a business partnership just runs out of road? It's a great way to put it. And the law has a really clear answer. An LLP that can't pay its debts doesn't just vanish into thin air. A whole formal process gets triggered to handle the dissolution, make sure creditors are protected, and bring the whole thing to a clean finish. Okay, so here's the game plan for today. First, we'll look at the signs that an LLP legally can't pay its debts. Then, we'll see how the tribunal gets involved. After that, we'll talk about a super important document called the Statement of Affairs. We'll also cover who the liquidator is, what the final winding up order means, and finally, just how much power the tribunal has over all of this. It's a step-by-step look at the whole process.
All right, let's jump right into part one, when an LLP can't pay. So how does the law actually define this? When is an LLP officially considered unable to pay its debts? It's not just a gut feeling, right? There are very specific legal triggers we need to look at. And this number right here, 1 lakh rupees, is absolutely central to the whole thing. It might seem like just a number, but it's actually a critical legal threshold. This specific amount can be the very thing that kicks off the entire dissolution process. Let's break down exactly how that works. Okay, so under what's called Rule 25, there are basically 3 ways an LLP is legally considered unable to pay its debts. First up, a creditor is owed more than that 1 lakh rupees we just saw. They send a formal written demand for the money, and if the LLP doesn't pay up or sort something out within 21 days, boom, that's trigger number 1. The second trigger is if a court has already told the LLP to pay a creditor, but the LLP still doesn't do it. That's a pretty clear sign. And the third one is a bit more general. If it can simply be proven to the tribunal that the LLP can't pay its debts, considering all its liabilities. Any single one of these is enough to get the ball rolling. So once one of those triggers is pulled and a petition is filed, the whole situation shifts. It now goes to the central authority in this whole process, the tribunal. This is where the real power lies, and trust me, they have a whole menu of options for what to do next. And just look at the range of powers the tribunal has. It's not just a simple yes or no decision. They can straight up dismiss the petition, maybe even make the petitioner pay costs. They can make temporary or interim orders to manage the situation. Here's a cool one. They can actually try to save the business by ordering a revival or rehabilitation plan. Or they can go the other way entirely, appoint someone called a provisional liquidator to take over right away, and then issue the final winding up order. And that last point, make any other orders it sees fit. That tells you everything. They have huge discretion here. Okay, on to our third point, filing the Statement of Affairs. Now, this is a huge step for the LLP. When someone else, like a creditor, files the petition to wind up the LLP, the tribunal will order the LLP to submit this document. And let me tell you, this is not just ticking a box. It's basically the LLP's one big chance to have its say. And this slide lays out the stakes perfectly. It's a tale of 2 choices, really. If the LLP files that Statement of Affairs, they get to officially object. They can fight the petition, present their case, and defend themselves. But, and this is a big but, if they fail to file it, that's it. They lose their chance to oppose the petition. The door to argue their case just slams shut. It's a really simple rule with massive consequences. All right, so let's say the process is moving ahead. The tribunal now needs a person on the ground to handle the nuts and bolts of the dissolution. This is where the liquidator comes in. So who is this person and what's their job? Let's find out. So the liquidator isn't just some random person. According to Rule 29, they are an official appointed directly by the tribunal. And they're chosen from a special panel that's maintained by the central government, so these are pre-vetted professionals. Their entire job is to take control and manage the LLP's assets and the whole dissolution process. And to make sure they do their job right, they have to put up a financial security before they can even begin. It's like a guarantee to the tribunal that they'll handle things properly. And here we go. We're at the point of no return, the winding up order. This is the official, final decision from the tribunal that the LLP will be dissolved. Once this order is made, it triggers a very specific and time-sensitive chain reaction of notifications. Everybody has to be told, and fast.
So check out how this unfolds according to Rule 31. On day 0, the tribunal makes the order. From that moment, they have up to 15 days to get the official notice out to the liquidator and the registrar. As soon as the liquidator gets that notice, a new 15-day clock starts ticking for them. They have to quickly notify every single stakeholder. We're talking partners, employees, creditors, everyone, that it's official, the LLP is being wound up, and they are now in control of all the assets.
Now, this part is incredibly important because it affects people's lives directly. That winding up order, it's legally considered a notice of discharge for every single person working at the LLP, officers, employees, everyone. In simple terms, it means their jobs are terminated. Unless the liquidator decides to keep the business running for a little while, that order is effectively their pink slip. It's a really stark and immediate consequence of the whole process. Okay, for our final section, let's zoom out and look at the tribunal's ultimate authority here. They don't just make the winding up order and then disappear.
Oh no.
They stay in the driver's seat and have complete control over absolutely everything related to the dissolution. And Rule 32 spells this out so clearly. The tribunal is the one-stop shop for everything. Any lawsuit for or against the LLP goes to the tribunal. Any financial claim, tribunal. Any last-ditch effort to revive the business, tribunal. Literally any question, whether it's about the law or the facts of the case that has anything to do with the winding up, it all goes to the tribunal. This is so important because it keeps everything in one place and stops other courts from making conflicting rulings. It's all handled right here. And this quote really brings it all home. An order of winding up shall operate in favor of all creditors and all the partners. What that means is, this final decision isn't meant to help just one person or one group. It's a binding order that's designed to create a fair and orderly process for everyone involved, from the biggest creditor down to the last partner. It puts everyone under the same set of rules. Here's the game plan for today. First, we'll look at the all-important report from the liquidator. Then, we'll see what the tribunal does with that information. After that, we'll explore the 3 different ways this can all play out for the LLP. We'll also cover how assets are protected and how fraud is handled, and finally, we'll wrap it all up.
So where does this all begin? Well, the whole process kicks off the second a winding up order is issued. But this isn't like flipping a switch. Nope, it's the start of a very structured procedure. And step 1 is creating a super detailed report on exactly where the LLP stands. That's the million-dollar question, right? Someone has to step into what could be a total mess and make sense of it all. And that someone is the liquidator. You can think of them as a kind of financial investigator, whose main job is to create a complete, totally accurate picture of the LLP's situation for the tribunal. And get this, they're on a super tight clock. The law gives the liquidator just 60 days from that winding up order to get their report in. You might be asking, why the big rush? Well, it's because time is literally money. Every day that goes by, assets can lose value. So moving fast is absolutely crucial to protect what's left for the creditors. And when I say detailed, I mean detailed. This report is massive. As you can see here, it goes way beyond just a simple list of assets and debts. The liquidator has to document everything: cash, property, contracts, legal battles, you name it. It's a full-on, exhaustive inventory of the entire business. And here's a really crucial point. This report isn't just a history of what happened. It's a strategic analysis for the future. The liquidator can actually recommend steps to get the most money out of the assets. It really sets the stage for every single decision that's about to be made. Okay, so the liquidator's report is in. Now the power shifts. The ball is in the tribunal's court, and it's their job to use all that info to decide what happens next and set the course for the whole winding up process. What's really interesting here is just how methodical this is. First, the tribunal digs into the report. Then, based on what they find, they set a hard deadline for the entire process to be finished. This isn't some open-ended thing. There's a clear finish line right from the start. And this is where you see the tribunal's practical authority really shine. If they look at the situation and realize that dragging this out is just burning through cash that could go to creditors, they can shorten that timeline. It's all about preserving whatever value is left. But, what if the liquidator genuinely needs more time? Is there any wiggle room? Yes, but not much. If the liquidator makes a good case, the tribunal can grant an extension. But even then, it's capped at a maximum of 30 extra days. The pressure is always on to wrap things up. And this brings us to the big turning point.
We've got the report, we've got the timeline. Now the tribunal has to make the huge decision about the ultimate fate of the LLP, and it's not always as simple as just shutting everything down. Not at all. And this is where things get really interesting for everyone involved. You might think winding up automatically means game over, but the law actually allows for a few different outcomes. The tribunal has 3 distinct paths it can take. First up, path 1. They can sell it. The tribunal might order the LLP to be sold as a going concern, which means it keeps operating under a new owner. That's often the best case scenario because it can save jobs. Or they could just sell off the assets piece by piece. They can even create a special committee to help make the sale happen. Path number 2 is kind of the comeback story. If the report suggests that the business itself is actually solid, maybe it was just poorly managed, the tribunal can order its revival. This gives the LLP a second chance to restructure and get back on its feet. And finally, if a sale doesn't work out and revival just isn't in the cards, we go down path number 3, final dissolution. This is what happens when the other, more constructive options have been ruled out. It's the end of the road. Now, this is super important to understand. While all this is going on, the report, the decisions, the potential sale, there are 2 critical things happening in the background to make sure everything is done by the book. And this slide really shows the 2 top priorities. On one hand, you have the protection of physical assets. The liquidator has to immediately take control of everything to make sure its value doesn't just disappear. And on the other hand, you have accountability. This whole process gives absolutely no cover to anyone who might have committed fraud. And the law is crystal clear on this point. If there's even a hint of fraud, a separate investigation is ordered, and it runs at the same time as the winding up. You can't just dissolve a business to try and make your legal problems go away. It doesn't work like that. Okay, let's bring it all home. We've walked through the entire path from that first winding up order all the way to the final outcome. So what are the key things to remember from this whole process? So in a nutshell, first, there's a deep dive investigation. Then, a court-directed plan with a firm deadline. The business's fate, be it sale, revival, or shutdown, is carefully considered. And all the while, assets are being protected and the system is on the lookout for any wrongdoing. And that really gets you thinking, doesn't it? When a business winds down, you've got partners, creditors, employees. A lot of people have a stake in what happens. So who's the referee here? Who makes sure everyone plays by the rules? Well, we're about to meet them and learn their playbook. Okay, here's the best way to picture this whole process. Think of it like a controlled demolition of a huge building. It's not just a random, messy collapse. It's a carefully planned event with a detailed blueprint, a lead engineer, and a ton of safety checks. So let's take a closer look at that blueprint.
First things first, when an LLP dissolves, there's usually some money or assets left. So the very first question the rulebook answers is a big one. Where does that money go? And believe me, there is a very strict pecking order.
The logic here is actually pretty simple. Before anyone else gets paid, you have to cover the costs of the demolition itself. That means paying the person running the show, the liquidator, and all the expenses that come with winding things up. Makes sense, right? You gotta pay the crew doing the work. Only after that's all settled do the LOP's creditors get paid. And see that term pari passu? It's just a fancy Latin phrase that means on equal footing. It ensures all the creditors are treated fairly. No one gets to cut in line. So, who is this lead engineer in our controlled demolition? That would be the liquidator. This is the person or company appointed to manage the entire process, and they have some pretty serious authority to make sure the job gets done right. And let me tell you, the liquidator has some serious clout. They can decide to pay off an entire group of creditors, they can negotiate deals and settlements, and they can even make compromises with partners who might still owe money to the LLP. These powers are absolutely crucial for a smooth process because it lets them sort out complicated financial messes efficiently. With all that responsibility, you gotta wonder, is the liquidator supposed to be a one-person show? I mean, can a single person really handle all the legal, financial, and logistical details of taking apart an entire business? Of course not. No way. No way. Even the best lead engineer needs a specialized crew. With the green light from the tribunal, that's the special court that oversees these cases, the liquidator can bring in all sorts of experts. We're talking accountants, lawyers, valuers, you name it. This makes sure that every single part of the dissolution is handled by a total pro. Okay, so we've got a powerful liquidator and they've got their team of experts. But wait a minute, who's keeping an eye on them? Who watches the watchers? Well, the system has that covered too, with a few different layers of oversight to keep everyone accountable. I want you to remember this number. 12.
That's the maximum size of a really important group that serves as the first line of defense, the first layer of oversight, watching everything the liquidator does. It's called the Committee of Inspection.
Think of this committee as the on-site supervisor, They're appointed by the tribunal, and their whole job is to work with the liquidator, keeping tabs on the process. They can call a meeting whenever they think it's necessary, and, this is the key part, the liquidator has to report what happened in those meetings right back to the tribunal. It's a direct line of supervision.
And this isn't just a one-and-done kind of check-in. Oh no, it is a constant cycle. Every single quarter, the liquidator has to file an official report, it's called Form 13, with the tribunal. This ensures that progress is always being tracked and keeps the whole process transparent and moving forward.
But what happens if something goes wrong? What if you're in the middle of this and you feel like a decision was just unfair? Well, the rulebook has safety nets built right in for these kinds of situations. This is where we talk about appeals and who is ultimately held accountable.
Let's make this real for a second. Imagine you're a creditor, or maybe a partner in the LLP, and the liquidator makes a call that you think is just plain wrong, and it negatively affects you. Are you just stuck with that decision?
Absolutely not. You have a voice. Anyone who feels they've been wronged by something the liquidator did has the right to appeal to the tribunal. The tribunal then acts like a judge. It'll review the decision and it has the final say. It can agree with the liquidator, completely reverse the decision, or change it. That's a huge check on the liquidator's power.
So it's really helpful to think of this as two different levels of oversight. You've got the tribunal, which is using a magnifying glass. It's focused on the tiny details of one specific LLP's dissolution. But then you have the central government, which is looking through a telescope. It's watching the big picture, supervising the conduct of all liquidators to make sure the entire system is running with integrity. It's a smart approach that catches small problems and prevents big ones.
All right, as this whole thing starts to wrap up, the focus shifts to something that is absolutely critical: creating a clear, transparent paper trail. Every single step, every decision, it all has to be documented. And the rules for keeping records are incredibly strict, for good reason. The liquidator has to maintain detailed books, almost like a diary of the whole financial process. Then those books have to be professionally audited to make sure every number is correct. And for total transparency, a summary of those audited accounts gets printed and mailed out to every single creditor and partner. Everybody gets to see the final math.
So, after all of that, the payment hierarchy, the oversight committees, the quarterly reports, the appeals process, you might be sitting there thinking, wow, why does this have to be so complicated? Why so many rules? And the answer is actually really simple and really important. Every single one of those rules is there to protect the people involved. The whole structure is designed to take what could be a messy, emotional, and confusing situation and make it fair, transparent, and accountable for everyone. It's not a blueprint for failure. It's a blueprint for a just and orderly conclusion.